Your lordships have been hearing this matter. Another difficulty is that every lawyer, Lord, is capable of arguing for hours together, days together. Lordships have been called upon to. There is some audio.
Yes.
So, Lord, the submission is this, Lord, that the issue which the lordships have been called upon to address or to decide, adjudicate upon, is no more recent in integra. Every court, Lord, I will take it when my turn comes. I'm only requesting, Lord, that since this has got now, it is not confined to Indian territory. The news is being blown out of international media also. Today's Dubai's Khaleej Times carried the news. So, Lord, therefore, what I request is this, Lord, that let it be decided as expeditiously as possible, and Lord, all of us, Lord, may confine ourselves, Lord, to the limited area in which, because already, Lord, your lordships have been kind enough to spend a lot of time on this. That's the only request, Lord.
On a lighter view, Lord, I would make a statement and a small request also. Your lordships know what David Panic said in his book on judges. He started the book by saying that judges do not have an easy job. They repeatedly do what the rest of us seek to avoid, make decisions. In this case, apart from making decisions, your lordships are burdened with controlling the queue as well. My suggestion, humble suggestion is only this. But if your lordship prescribes the order, it is your lordship's prerogative, and the time for each person, your expected time, that will be easier to get concluded. If there is an order, we will follow the order prescribed by your lordship.
Perhaps I would support that, subject to everybody agreeing. Some time limit, only in order to ensure that I would not, including me,
our suggestion is that one lawyer shall argue one petition.
Yes.
And unnecessarily argument shall not be repeated.
Yes.
That's correct. Absolutely.
The second thing is that from the cause list, we find that so many IAs have been filed with this regarding the intervention. Now, what we feel,
yes,
that all these intervention applications,
yes,
which have been filed by various parties, they are not required to be considered.
Yes.
Because,
yes,
because these are not, this is not a PIL.
Yes.
In the PIL, we can understand, yes, the intervention moved, yes, by the public.
Yes. In fact, Lord, I may bring to in the dissenting judgment in Shabarimala, that is Lordship Justice Indu Malhotra. But this question did come, Lord, in a religious matter. Could the intervention applications and others could participate? The court was very reluctant.
These are the writ petitions filed by individual persons.
Yes.
Now they are being heard.
Yes.
They are being represented by senior advocates.
Petitioners. Yes.
Already sufficient arguments have been advanced in two of the petitions.
Yes.
Now, where is the question of considering these intervention, yes, applications? One application for impeachment proposed applicant as petitioners. Now, how this impeachment application is to be considered? Now, all these applications, they will unnecessarily waste the time, yes, of, yes, the court.
Malaz, so, may I make a submission, Malaz, in light of what my lord
yes,
said?
We will consider each application, will pass separate orders on each application, but we are just giving you the idea, yes, that this unnecessarily will waste the time of the court, and these applications, what prima facie we feel, are not maintainable.
Yes. Malaz, may I just make one submission?
Lord, absolutely
Malaz,
right.
in light of what's fallen from the court, Malaz, may I just make one submission? Malaz, some of the, Malaz, normally what your lordships are saying is absolutely correct. But this is an issue, Malaz, of, for instance, Malaz, I have filed for a woman's
PILs are also there. Mr. PILs are also there before us. Two PILs are there. We will hear the PILs also.
I'm just saying one thing. Your lordships may impose time on us, 15 minutes, 20 minutes, no more per counsel, no difficulty. Because what I am going to submit, for instance, is on an aspect of international law and obligation in this context. I am sure nobody else is placing that point. So all I'm saying, your lordships may hear us. Please impose time limits. We'll abide dutifully with that. But please don't exclude without hearing.
Highlighting the international aspects, Milord, for that matter.
All right, first start with the proceedings.
Yes. My lord, may I also make one submission? Yes.
Mr. Dar, you will have to first unmute yourself.
Subject to your lordship's approval, as your lordship's right, my lord, we salute your lordship that patience everybody has been given time to advance the arguments. We are thankful for that. Your lordship may spend some time, and preferably, so this is a constitutional point, and also on the religious side, your lordship may give a preference to the senior designate lawyer, say will address. And whenever your lordship is subject to your lordship approval, get the time. As your lordship rightly said yesterday, that your lordships are not in a hurry. It is better, my lord, that if the senior advocates who are designated can address properly and can convince your lordship and can address the point of law. I think that should be the first endeavor of the my lords, that is subject to your lordship's approval. I pray for that.
All right.
I may also say, my lord, since it involves a constitutional issue, but
Yes.
the Supreme Court also repeated this that at least in two judgments, my lord, where the locus is generally...
All that is being argued before by the people of states. They are duly represented. All these petitioners are duly represented. If we require any assistance, then we will call upon you people all to come and address the court.
Only on...
Absolutely right. Absolutely.
I may clarify a very short point, because it involves a constitutional issue, unless and until we are able to provide your lordship something distinct from everything else. But we are not seeking that opportunity. Otherwise, but the locus is generally broader. It's not as if we are deciding an inter-party issue. It's of enormous constitutional importance. Therefore, lordship may permit us for 5 minutes. The moment we repeat, the moment we say something.
All right, we will consider. If we require, we will consider your request.
My lords are right.
First, let us finish with the arguments of the petitioner and the respondents.
Yes.
Yes. Yes, who has to argue?
Yes, professor is on his
Yes. Yes, Mr. Kumar, you were...
I was pointing out from the provisions of the Act.
Yes. Yes, we had noted that.
Yes. So kindly permit me to show prescribing a uniform
Yes.
disciplinary action against the students, which is a police power, is not vested expressly under any provision of the Act or the rules. On the contrary, kindly come to 1995 rules, on which the respondent has heavily relied upon. The court is having this blue book. Kindly come to page 305. In this manual on education.
Yes.
305.
Yes. Rule 11.
Yeah, Rule 11 may kindly please. Provision of uniform, clothing, textbooks, etc. Every recognized educational institution may specify its own set of uniform. Such uniform, once specified, shall not be changed within the period of next 5 years. When an educational institution intends to change the uniform, as specified in Sub-Rule 1 above, it shall issue notice to parents. Kindly mark it. It shall issue notice to parents in this regard at least 1 year in advance. If there was to be a ban on hijab, that should have been notified 1 year in advance, and only thereafterwards matter can be considered under this rule. Now, Rule 3 is not necessary. Kindly mark another rule, Rule 12. It's a very important rule. Parent-teacher committee. It shall be the duty at the head of every recognized educational institution to constitute a parent-teacher committee within 30 days of the commencement of each academic year. Till a committee is constituted under Sub-Rule 1, the committee constituted in the preceding academic year shall continue in function. The parent-teacher committee for each educational institution shall consist of the following. Composition is given. The functions are given in Sub-Rule 5. kindly note that everything that could be coming under the uh, curriculum as well as the other aspects of students' career in an institution is covered by this. The parent-teacher committee is authorized to deal with it. Now, while this is the provision made under the 1995 rules, which are general in character, the pre-university colleges, we come under the pre-university college. There is another set of rules that are framed under the Act. Kindly come to page 1353.
Page
1353.
Yes.
Rule 2 may kindly be seen at 135455. Government PU college is defined. Sub-rule 6. Government pre-university college means a college established and administered or maintained by the state government. It does not include a private college whose management has been taken over for a limited period for the purpose of better management. Sub-rule 7 speaks of an inspection committee. And it is very important to take note of the fact that the College Development Council is not one of the authorities established or recognized under these set of rules.
This we have noted yesterday that.
Yes, this being the position. Now I would request the court to kindly take note of this fact that the government order I have already shown, it has declared that there is no uniform prescribed for PU colleges. Now, incidentally, the prospectus issued for the current academic year, it is of course produced as an annex to the other petition. I have placed, I request my colleague Mr. Tahir to give a copy of the translated, because the original is in this document is Annexure J. Annexure J at page 49. In WP. I've given an English translation. The original is in. Kindly come to this list of documents. Don't close before the court. Page 3 is the cover page of the.
We have Kannada of that.
Kannada.
What is that? I have to see.
Yeah. Annexure J at page 49. WP 2146. May I draw the attention? So in this, there is a special notice under the heading special notice. Certain instructions. There is a bullet point presentation. Kindly come to page 9. These are the instructions given for the current year, current academic year. It's very extremely important. Kindly permit me to read the last bullet point, page 9. May I read the guideline? Uniform is not mandatory for students studying in pre-university college or pre-university education department or education act. But some college principals and management committee members have imposed uniforms as mandatory, which is illegal. Kindly mark. Prescription of any uniform is declared illegal. There is no uniform prescribed.
Government colleges.
Yeah.
This is for pre-university.
Pre-university government college.
Pre-university government colleges.
Yeah, ours is a pre-university. Respondent 5 is a pre-university government college. Next sentence is very important. Okay. Anyway.
Now, what is this document?
So these are this is in the nature of the guidelines issued for the academic year 2021-22 by the department which is administering this institution. This is the government department, namely Department of Pre-University Education.
So who has issued it?
Who is the author of these instructions?
To whom it is issued and who has issued? Nothing is given this. It only talks about allocation of admission seats.
Please.
These are to be followed in government pre-university colleges.
Yeah.
Now, who has issued this? Under what authority? Nothing is given.
No, this is in the nature of the regulations in the form of guidelines issued by the government for all the PU colleges coming under its administrative control, namely the government PU colleges.
It cannot be a regulation. Cannot be a regulation.
It is not a rule. I respectfully agree. It is not a rule, but it's a statement of fact that no uniform is prescribed.
But the thing is that under whose authority this document has been issued by the government, whether it is a government's document and who has issued it, under what authority?
It is the
Nothing is described.
It is the annual guideline issued by the Department of Pre-University Education. No, I am not.
Assign certain powers to the government. Some departmental undersecretary is issued.
No force.
No, I am not saying that it has a force of law. All that I am pointing it out is as a statement of fact. There is no.
We want to know whether it has been issued under 131.
No, this is not an order.
133 of the Act.
It is not an order. It is not an order.
Not an order.
The order also recognizes this fact that no uniform is prescribed for government colleges. I've shown it yesterday.
That's all right, Professor. That we will come to. That's another aspect.
Please.
Question is, you are pressing into this instrument in support of your contention. Honorable Chief Justice wants to know, as we also, what is its legal status? That you have to demonstrate. If you want to bank upon. If you give up, then we will go further.
Now, Karnataka Education Act
I don't claim,
133
I don't claim
gives the
any
power
legal
government to give
validity for this, but for the fact that this gives the current year's academic program. They kindly come to the Kannada version may kindly be seen. Full document is there. Entire document is placed before the court. The calendar for the academic year is given, and about the admissions to be made for each course. Details are given. Then how are the admissions to be made? That is given in chapter 3. Then chapter 4 deals with the students with disability. Chapter 5 deals with the provision for changing the subjects once a student is admitted. What is the procedure to be followed? When is he eligible to be granted a change of subject? How many such subjects can be changed? That is given in chapter 5. Chapter 6 is very important for us. Under chapter 6, Vishesha Suchana, that is special notice. Special notice. And in that, the bullet point. This is part of chapter 6. No, I'm not enforcing. Permit me to say it again. I'm not enforcing this document. I'm only placing it before the court as to what the department itself has said. For the current academic, emphatic statement, no uniform is prescribed. Emphatic statement that no principal shall enforce a uniform. And an emphatic statement that the principal will be proceeded against in a disciplinary inquiry if he insists on uniform. Not the students. Here, very strange this thing is that the students are being proceeded against on the ground that they are wearing hijab. So with this fact, and court may note the fact that neither the provisions under the Act nor the provisions under the two set of rules prescribe any uniform. Neither under the Act nor under the rules is there a prohibition to wear hijab. Expressly kindly mark this, there is no prohibition to wear hijab.
No, that may not be the correct question. If that view is adopted, somebody may say there is no prohibition to carry the licensed arm in the classroom. The correct position is not reflected in your question. Question is too broad a proposition which would admit universe in that.
No.
Going by your version, logically, you said there is no prohibition as such. I'm just logically analyzing to what level your proposition can take us to. There is no prohibition for carrying the krupan, no prohibition for carrying anything which otherwise is objectionable in the classroom, because these are not spoken of by the Act. That may not be. Independently, if power to prescribe is recognized now, even the text which you have read of Rule 9:11, power to prescribe uniform is available. It is true. It does not say whether hijab should not be permitted, should be permitted. That is true. So that has to be independently argued if there is such a prescription.
With great respect, I go down to the observation of the court. The very document which I have placed reliance, the whole text is not placed before the court in translation. But kindly see Annexure J in the connected petition. Comprehensive. All the aspects on which the court was pleased to observe. They have been provided for. No, I'm not expanding the proposition I have made. I am only saying there is no prohibition against hijab. So therefore, the question remains as to under what authority I have been kept out of the class. Under what authority? Under what rule? Who has authorized such an act? And now the government order is issued. Kindly come back to the government order once again. I request the court to kindly come back to the government order. In this compilation also I have placed the document at page 25. Translation is there.
Please, 25.
Yes.
One statement in the preamble at page 26. Page 26, kindly permit me to show. One of the statements is Para 2. Student programs will be conducted for the convenience of all the boys and girl students to take part and bring in uniformity. However, in certain educational institutions, it is noticed that several students are following the practice as per their religion.
Which page you are reading, sir?
Page 25, the document starts.
26 it starts.
Kindly come to the next page. Next page, Para 2 may kindly be perused. Student programs will be, that is how the paragraph commences.
Yes.
Yeah.
27.
Yeah. Student programs will be conducted for the convenience of all the boys and girl students to take part and bring in uniformity. However, in certain educational institutions, it is noticed that several students are following the practice as per their religion. Kindly stop it. This is a direct indictment of those who have come with hijab. So they surmise that it's going to affect the equality, unity, and then come to the next page, last paragraph in the next page. Last paragraph. as per the above mentioned decisions rendered by the Honorable Supreme Court and various high courts, to direct not to wear headscarf, kindly mark it, to direct not to wear headscarf and also not to allow covering of the head is not violation of Article 25, and also the government has, after thorough interpretation of the Karnataka Education Act, has ordered here. So the final order. Next page. Next page, para 2 make it. Para 2 next page.
Yes.
Yes.
Colleges coming under the jurisdiction of the Pre-University Education Board shall wear the uniform as per the respective college development committee as administered. Kindly mark it. In a circumstance where uniform is not prescribed by the governing body, it is directed to wear such uniform which protects equality and solidarity and which will not affect public peace. In other words, the government has delegated the power to prescribe the uniform to the College Development Committee. May I request the court to kindly take the Education Act for a minute. Legislature has expressly authorized delegation of power to authorities coming under the Act. Kindly come to page paragraph section 143 of the Act. Page 140, section 143 deals with delegation. Yes. May I read that? The state government may, by notification in the official gazette, delegate all powers exercisable by it under this Act or rules made thereunder in relation to such matter and subject to such conditions, if any, as may be specified in the direction to be exercised also by such officer or authority. Kindly mark it. Such officer or authority subordinate to the government.
Yes.
I have already shown. College Development Council is not an authority. Much less is it a subordinate authority to the government. So no delegation can be made in favor of it. Be that as it may, kindly take the government order by which College Development Council is constituted. 2014 government order I can give you. Last document in the compilation I have just now handed over. Just now. Page 31 is the original in Kannada. It is dated 31st January 2014. Its English translation is at page 32. That is the last page of this compilation. Last document.
Yes.
Yeah. This is a circular. This is a circular. Not an order. Issued by the Undersecretary. Not even an order in the name in the name of the governor. It's a short order, may be permitted to read the circular. Education Department is providing first and second PU education in the state. PUC education is the main stage in the student's life. In accordance with the government and department direction, and in order to utilize the grants, kindly mark it.
Yes. This constitute the Development Council.
Yeah. In accordance with the government and department direction, and in order to utilize the grants, kindly mark it. First purpose is to utilize the grants, as well as in maintaining academic standards, second one. And third, and development of infrastructure. We are hereby directed to form a college development committee and follow the guidelines. Sir, this is not a committee constituted for purposes of dealing with the students' welfare, students' discipline, or exercise any kind of police powers over the
Maintaining academic standards.
Academic standard is for the academic standards only, not with reference to the students. And more important,
whether the uniform cannot be prescribed by the colleges to maintain the academic standards.
With great respect, it has no connection whatsoever with the academic standards. Academic standards deal with student-teacher ratio. Academic standards deal with the curriculum, the syllabus, and the way the classes are conducted, etc., etc. It cannot be, by any stretch of imagination, connected with prescribing or exercising police powers over the students. Like
why it can't be read that it may, for the maintaining uniformity, discipline, the uniforms are necessary, and in order to maintain academic standards.
Sir, that I have pointed out, that field is already occupied. It is covered by the Act. Section 7 covers all these aspects. Now, can such a body be entrusted with police powers over the students? Is the short question. Now, kindly note the composition.
What is that police power, sir?
Police power is to discipline the students.
Uniforms are prescribed in Sanskrit Pathshala. It is not a police power. They are if it is prescribed to police people, military people, defense, I can understand. In educational institutions, what is prescribed cannot be said to be in exercise of police power.
Supervision and control over the students is the police power that is contemplated. Whether a student can be restored, whether the student can be brought under any particular rule.
Very judicial opinion is contrary to what you are saying.
Yeah.
Judicial opinion is contrary to what you are saying. It's never treated as police power in any civilized jurisdictions. Except parental power. What's now treated is parentis potestas. Never police power. If you cite one single dish, I'll be extremely happy. I will confess that I am wrong. One single authority.
No. The power to discipline students is the power I have referred to as police power. Now, that is not what I'm saying is this order does not entrust that work, that responsibility, that function to this committee. Be that as it may, kindly look at the composition of the committee.
You say that this College Development Committee has no power to prescribe uniform.
Yeah, no power to prescribe uniform. Secondly,
yes,
this is a committee to which no power can be delegated under Section 143. Because this is not an authority under the Act, much less is it an authority or an officer subordinate to the government. I asked this question myself. Can MLA be considered as subordinate to the government? If this committee is considered as a subordinate to the government, MLA becomes a subordinate to the government. Sir, the other day court was pleased to ask a very pertinent question. What is wrong if the MLA is appointed? If I may say so with respect. Under our constitution, it is the representatives of the people, either MLAs or members of the parliament, who hold the government accountable. The hallmark of Indian democracy is accountability of the government through our elected representatives. Here is an MLA who is endowed with administrative powers. To whom is he accountable? This takes away that basic quality of Indian democracy, namely accountability of the government. Now MLA takes over the administration. Apart from the fact that the doctrine of separation of powers ensures that there is no mixing up of the two functions, namely the legislative function and the executive function. So, one MLA or member of the parliament for that matter cannot be entrusted with any power either under the statute or under the constitution, Article 162. This is unknown, sir. This entrustment of this. Court was also pleased to ask whether there is no other committee constituted under the chairmanship of the MLAs. I go down to that question. Sir, I have my colleague who is there before the court. In the year 2015, on 16/11/2015, the government constituted a committee under the chairmanship of the local MLA for preparing the list of beneficiaries for distributing house sites and houses under the free housing scheme, like Rajiv Gandhi, Jagjivan Ram, Atal Bihari Vajpayee, B.R. Ambedkar Niwas Yojana. These are all the schemes under which kindly see for a minute. I've passed on the document.
Was it struck down by some court?
Sir, I myself argued this.
Therefore,
the order is stayed. If I may say so with respect, this order is stayed in WP number 6015 of 2017. WP 6015 of 2017. By an order dated by an order dated 14th February 2017, this order has been stayed. Thereafterwards, the government moved for vacating the interim order. That was also considered. And without vacating, modifying the order, the stay was continued. At the same time, the scheme was permitted to be implemented without reference to this. That is the order dated 15/6/2000. So this is the legal position when another committee was constituted to the FLA. Sir, everything is wrong to give the MLA administrative powers. That will be a death blow to Indian democracy, because MLA should be fearless on the floor of the House to hold the government accountable. He becomes accountable for the exercise of his powers. Kindly look at the powers given. Handling the grants, financial powers, building the infrastructure. That is the major source of corruption in every department. And more importantly, I request the court to kindly take judicial note of the fact that MLA, whoever he may be, he will be representing a political party, a political ideology. Sir, can you entrust the welfare of the students to a political party or a political ideology? With all humility at my command, I very respectfully submit that constitution of a committee of this nature spells a death blow to Indian democracy, doctrine of separation of powers, and the doctrine of accountability of the government. I therefore very respectfully submit that the order delegating this power has to be ignored because it is not statutory in character. And don't allow this committee to handle the welfare of the students, exercise power, disciplinary power against them, check them out of the classrooms on one pretext or the other. Sir, the other thing I want to stress upon is, I have another report, this thing, Honorable Chief Justice may be very familiar. In South India, we are very fond of religious symbols. By and large, everybody goes to any place, particularly a public place, Even our teachers used to come with religious symbols exhibited either on their forehead or on their, they used to wear caps those days. And in South India, the extent to which this symbol, religious symbol, Honorable Mr. Justice Dikshit is very familiar with this. Sir, there was a temple elephant. The question was, what type of religious symbol should be exhibited on the forehead of the temple elephant? One version said it should be Tengalai. Tengalai is one form of. The other said it should be Vadagalai. Sir, the issue is for nearly 250 years. Matter went up to the Privy Council. By the time the final decision came, the elephant was dead. And the verdict came, 6 months you put Vadagalai and another 6 months you put Tengalai. Sir, this is
that should not happen in this case. Professor, that should not happen in this case.
I very respectfully agree. That should not happen. It has to be nipped in the bud. I agree. It has to be nipped in the bud. Sir, 250 years this issue was fought. The great Parasaran argued the last case, if I remember. And the unsuccessful party, what it did after the decreed Namam was painted on the forehead, he went and put a head cover with a different Namam. Then they were threatened with arrest and the decree was enforced. In fact, Mr. Parasaran represented that dismissed. Why I am saying this is, now kindly come to a research paper I have placed before you, just by way of information. Here. My learned colleague will give the copy of the research paper. There was some problem with the pagination, so I am giving one document at a time to avoid any confusion. Sir, this is a research paper which has conducted an exhaustive survey, a comprehensive survey on religious clothing and personal appearance. All the religious symbols are defined. I will not trouble the court, they are very familiar. Kindly come to the body of the paper. In addition to religious activities like praying, visiting houses of worship, or having a home altar, many Indians also display their religious observance through attire, including the use of special clothing, jewelry, and other aspects of their personal appearance, such as beards. Half of Hindus, 52%, and Muslims, 50%, majority of Christians, 61%, for instance, say they generally wear a religious pendant. And most Sikh men and women wear a traditional metal bracelet known as kara and follow the distinctive Sikh practice of keeping their hair long. Many of these practices are gender specific. The vast majority of Muslim men say they wear a skull cap, 84%, and most also have a beard, 64%. Similarly, Sikh men largely have beards, 83%, and wear turbans, 69%. Among women, wearing a head covering outside the home is a common practice among Muslims, 89%, Sikhs, 86%, and Hindus, 59%. The practice of covering the head outside the home is less widespread among Buddhists, Christians. Nearly 2/3 of Muslim women in India, 64%, say they wear a burqa. A burqa is a covering for the whole body including the face and head, but interviewers did not define the term for the respondents, leaving the exact definition, etc., etc. Then I'll not trouble the court with the other. Kindly come to the next heading. Half or more Hindus, Muslims, Christians wear religious pendants. Then next heading, the details are given. Empirical data is provided. Most Hindu, Muslim, Sikh women cover their heads outside the home. Every college-going student wears a dupatta. Kindly take judicial note of the fact, whether Muslim or Hindu or Christian. Likewise, the next chapter gives
the authenticity.
Sorry,
Professor,
please.
What is the authenticity of this paper?
Sir,
what is the representative character of the paper?
No, this is a research paper.
Apex Court said. No, Apex Court said.
Yes.
When research papers, so-called, are produced before the court should ascertain the authenticity and representative character of the findings in the research paper.
No,
therefore, I am asking this.
With great respect, I am not insisting upon acceptance of the empirical data that is provided in the paper. I am only bringing it to the notice of the court. The diversity prevalent in the country. Kindly look at the number of religious symbols, both among men and women, among students and non-students. Detailed category-wise details are given. I am not insisting on accepting this. Sir, if there are 100 symbols, why is the government picking up only hijab? Why is it not finding anything wrong with the other
consider.
Bangles? Bangles are worn.
Unless
only for that limit.
I'm just telling the position of law says, unless a paper's authenticity is prima facie established by producing who authorized this research, who undertook this research, who approved this research, what are the research methodology principles on which paper is constructed. Unless these are established, you can't just go by what says it bears in our forehead.
No. With great respect, I am not insisting on accepting any of the data that is provided. Please consider the number of religious symbols which have been enumerated there. This honorable court may take judicial notice of this fact. These are all the religious symbols prevalent in the society. Hindus have their religious symbols. Sikhs have their religious symbols. Christians
only to the extent of plural symbols being provided.
Yes.
It only shows the plurality of the symbols. To that extent, we will take note.
I am only here to demonstrate the plurality of our society, the diversity that is prevalent in this society. Why is only hijab picked and chosen for this hostile discrimination? Is it not because of their religion? It is for that limited purpose to demonstrate the vast diversity in the society and the number of religious symbols among all sections of the society. Sir, in the army, turbans are allowed for the Sikhs.
We have taken note of this.
Yes.
So bangles are worn. Are they not religious symbols? I ask this question myself. Why you only pick up these poor Muslim girls? Now that is bad. Kindly show Article 15 specifically any discrimination. Constitution Bharat. Clause 1 of prohibition of discrimination on grounds of religion, race, caste, death, place of birth. The state shall not discriminate against any citizen on grounds only of religion, race, sex, place of birth, or any other. This is only because of her religion, that the petitioner is subjected to this. Only because of her religion. Because a dupatta is not banned, a bangle wearer is not sent out of the classroom, a bindi wearer is not sent out, a Christian girl carrying the crucifix. Every Christian carries a crucifix on her neck. They wear pendants. They are not touched. Why only these girls?
On the religion.
That's what.
So this is my next ground of attack on the impugned action.
You say that the Article 15 prohibits the discrimination on the ground of religion.
Yeah. Therefore, hijab being subjected to this hostile attitude.
It says headdress
Yes.
by anyone, not any particular persons belonging to particular religion.
To all persons.
So all persons, they say about it. So how?
Hijab is worn only by Muslims. Sir, Gunga.
Suppose if a Hindu also wants to wear, he cannot.
If anyone else wears, then
Gunga.
whether it is permitted.
Gungat is permitted. Yes, Gungat is permitted, not banned. Bangles are permitted. Is it not breaking the uniformity? Bangles are not.
We are talking about the headdress.
No. Headdress is one religious symbol.
Headdress.
There are other reasons why I gave this paper to show how many religious symbols are there in the society. I just wanted to demonstrate the plurality of the use of symbols, religious symbols. Why only this? Why not the crucifix on the neck of a Christian student? Why not the turban of a Sikh student? Sir, the matter is no longer reciprocal, if I may say so with respect. Immediately after the Constitution came into force, even before the ink on the Constitution was dry, matter was taken before the Honorable Supreme Court. There were what are known as communal electorate, and for Ottawa municipality in UP, elections were held on the basis of community for separate electors. That came up before the Honorable Supreme Court has declared it as void. AIR 1953 Supreme Court, page 384. Copies will be given by my
AIR
1953 Supreme Court, page 384. May I pass on a copy of the judgment?
Communal electoral constituencies. That is.
Kindly come to page 385, just two small paragraphs. Para 3. Para 3. Now it cannot be seriously that any law providing for elections on the basis of separate electorates for
the
members
members of religious communities.
Yes. Separate electorate. It was hit by Article 15(1), that is the declaration of law, by a constitutional bench.
Yes. There is no dispute to that.
Para 4 reiterates this constitutional mandate to the state not to discriminate against any citizen on the ground inter alia of religion clearly extends to political as well as other rights can be marked as other rights. So therefore, this directly applies on all fours to this thing. Likewise, in Rajasthan there was a police rule, 1960 Supreme Court. Yeah, 1960 Supreme Court. Mr. Tahir, can you give a copy of? Yeah, 1960 Supreme Court, page 1208. Kindly come to the second page of this document, this judgment. Para 7, only one para. So the facts were that under the particular enactment, if there is any special force provided to a place, the members of the community were required to bear the expenditure of that police force. Two communities, namely Harijans and Muslims, were exempted from payment of this duty. Now that is what was under challenge. Para 7 may kindly be proved. Learned counsel for the state made a strenuous effort to show that the exemption of Harijan and Muslim inhabitants of the villages was in the impugned notification not based only on the ground of caste or religion or the other criteria set out in Article 15(1), but on the ground that persons belonging to these two communities were found by the state not to have been guilty of the conduct which necessitated the stationing of the additional police force. It was the same argument as was addressed by the High Court and was rejected as observed by the court. Now this is a very strange argument that only persons of a certain community or caste were law-abiding citizens, while the members of other communities were not. Distinguishing elements may be found among members of any community or religion just as much as there may be saner elements among members of that community or religion. The view expressed by the learned judges is, in our opinion, correct. Even if it be that the bulk of the members of the community is exempted, or even if all of them were law-abiding, it was not contended on behalf of the state that there was no peaceful and law-abiding person in these 24 villages belonging to the other communities on whom the punitive levy had been directed to be made. In para 5F for the petition filed before the High Court, the respondent has quote, that the aforesaid notification is ultra-vires the Constitution of India, as it discriminates among the citizens on a village on the basis of their religion, race, or caste, inasmuch as it makes a distinction between persons professing the Mohammedan religion and others, also between persons who are Muslims and Harijans by caste and the rest. It therefore contravenes the provisions of Article 15. The answer to this by the state was in this term that is quoted. It would be seen that it is not the case of the state, even at the stage of the petition before the High Court, that there were no persons belonging to other communities who were peace-loving and law-abiding, though it might very well be said, that according to the state, the great majority of these other communities were inclined the other way. If so, it follows that the notification has discriminated against the law-abiding members of other communities and in favor of the Muslim and Harijan communities, assuming that they are one of them was peace-loving and law-abiding on the basis of their caste or religion. If there were other grounds, they ought to have been stated in the notification. It is plain that the notification is directly contrary to the terms of 15.1 and that para 4 of the notification has incurred the condemnation as violating specific constitutional provision. In our opinion, the learned judges of the High Court were clearly right in striking down the paragraph.
All right, that we have seen.
So kindly consider this. No other religious symbol is considered in the improved government order. Why only hijab? Is it not because of their religion? I therefore very respectfully submit that the discrimination against Muslim girls is based purely on their religion. And therefore, first aid is.
Even if a person belonging to other community,
Please.
a lady belonging to, a girl belonging to other community, suffers from acacia, and to minimize the ugliness, she wears the headgear, comes to the school, she will not be permitted.
No, why? She is entitled for exemption. She can apply for exemption.
That's exemption.
No.
Exemption is another thing.
That with
An
great
exception to the general rule.
hard cases,
we are arguing.
hard cases bad law. Definitely, if there is a case where there is somebody, it is an exception, very rare exception. Definitely, they will be, they will not be barred because they are entitled to claim exemption, and we are not permitted to. We are not even heard. We are punished straight away, made to stand at the gate. Can there be a more draconian measure? Can they be called teachers who have shut us out of the classroom?
Yes.
Great respect. That analogy may not apply here for the simple reason that's a humanitarian case, which definitely anybody would be sympathetically viewing. Here it is full of prejudice because of the religion. We are not even heard. No notice. We shut out of the classroom by persons who have no authority or whatsoever under the act of the rules.
Yes.
All right.
So with this, I rest my second submission on the doctrine of discrimination based on religion. The third most important submission is that the goal of education is to promote plurality, not to promote uniformity or homogeneity, but to preserve heterogeneity. In fact, the world over, this has been very well recognized that the classroom should be a reflection of the diversity in the society. Honorable Supreme Court has also recognized in case Putswami's case more expressly. In Nalsa case, I'll place the judgments. I will not trouble the court with this thing.
Yes.
Yeah, may just give the relevant paragraphs. In 2008, 5 SCC page 33. Paras 41, 42.
Page number 2008, 5 SCC.
Page 33.
Read.
2008, 5 SCC, page 33.
Paragraph.
Paragraph 41, 42, 45, 46,
Yeah.
then 54, 56, and 58, where the historic role of Akbar the Great in maintaining peace and harmony and diversity in the society has been expressly noted by the Honorable Sir. In Navtej Singh Johar, where section 377 was struck down, 2018, 10 SCC, page 1. 2018, 10 SCC, page 1. Paras 97 by the Honorable Chief Justice. Para 4 and then para 6 and 10 by Justice Chalmeshwar. Then in Valsamma versus University of Cochin, Valsamma Paul versus University of Cochin, 1996, 3 SCC.
Yeah.
Page 545. Paras 22 and 25.
These are for the proposition. I'll write down. We'll write down the proposition also. There should be no uniform at all.
No. This is for the proposition that heterogeneity should be maintained. Unity in diversity should be the motto. Plurality of the society should be third. Then when the Right to Education Act came into the force, the validity of it was under challenge. This was in the Society of Unaided Schools of Rajasthan, 2012, 6 SCC, page 1. Paragraph 239, 240, 260, 239, 261. Heterogeneity should be maintained in a classroom is the goal of the new RT Education Act. This was a statement made by the Government of India, which has been placed onto. So my very respectful submission is that if people wearing turban can be in the army, why not a person sporting a religious symbol, which is her right to practice her religion, be allowed to attend classes? Sir, it's a draconian this, where universal education is, particularly girls' education. And court may take judicial note of the fact, among the girls, Muslim girls are the least educated, least represented in classrooms. If they are shut out on the ground of such discrimination, that will be spelling a doomsday for their educational career. Very rarely they come to the college. Even such girls are being shut out on this pretext. Would be a very draconian measure. So with these submissions, I on other submissions, since it has already been elaborately argued, I do not want to cover. In reply, if it is necessary, I will get back to the court. I am grateful to the court for giving this patient here.
Thank you.
Grateful, my lord, unless there is some senior advocate designated from the Karnataka High Court, then I may be given a chance, my lord. First preference is from that.
Petition number 4. What is number?
Right.
So please make of
Now we come to next case is 3038 of 2022. Mr. Yusuf Hatim.
Yes, my lord.
Yes, please make your submissions.
May I please, Your Lordship? Sorry. There's a lot of going on, so there's a lot of disturbance. I speak from Bombay, my lord, and there's some problem getting too much echo in the sound, and therefore, my lord, very often I have to repeat myself to make myself audible and to make myself properly understood by the court.
We are hearing.
Yes.
We are hearing you clearly.
Yes.
You
Your Lordship, not the petitioners before Your Lordship, my lord, my petition are also the Muslim girls, my lord, and they have been in the pre-university, my lord, classes, my lord, and pursuing second pre-university course, and wearing the headgear, hijab, my lord, without any remark or blemishes in their academic program, my lord, and they have been, my lord, stopped from attending these classes from 3rd of February 2022, my lord. And after this impugned order has come, they have been totally denied their right under Article 25, Redress 19(1)(a), 21, and the right to education. And my lord, similar issues have been raised in other petitions. And my lord, I will not repeat many of the things which have already been adverted to by the my learned friends who preceded me. And my lord, I totally endorse, my lord, all their arguments as one by Mr. Sanjay Hegde, Mr. Kamath, and also Professor Ravi Kumar, my lord, who just addressed and completed arguments at some time. But I seek your lordship indulgence, my lord, to merely elaborate one or two points very briefly, which I believe that they have touched upon it, but they have not made any elaborate arguments on that. The first point that I would like to say is this, my lord, that this particular impugned order suffers from manifest arbitrariness. It's manifestly arbitrary, and it also offends Article 14. Your Lordships are well aware of the legal propositions authentically laid down by the Supreme Court, my Lord, in the case of Saira Banu. Pardon. Laid down. My Lord, I briefly draw your Lordship's attention to only three paragraphs from Saira Banu's case, my Lord. And when I make my submission as to how this whole exercise of preventing the Muslim girls to wear hijab is manifestly arbitrary, my Lord. Your Lordship will see, my Lord, it is, my Lord, your Lordship has got, I believe, the case in the compilation. It is 2017 9 SCC, page 1. 2017, volume 9, SSC, page 1, my Lord. And my Lord, I am reading very briefly only certain sentences from paragraph 100 at page 97, my Lord. From the text of my Lord the Justice Nariman.
On what proposition you want to cite this, Saira Banu?
Yes, no, it starts from 100.
Proposition.
On manifest arbitrariness.
Pardon, Lord?
Pardon? You are citing.
Manifest arbitrariness.
All right.
Manifest arbitrariness. Now, pardon, Lord, my first read from paragraph 95, Lord, where the concept of arbitrariness and manifest arbitrariness is totally defined, Lord. Page paragraph 95 at page 95, Lord. On a reading of this judgment in natural resources allocation case, it is clear that this court did not put McDowell's as being an authority for the proposition that legislation can never be struck down as being arbitrary. Indeed, the court, after referring to all the earlier judgments, and Ajay Hamza in particular, which stated that the legislation can be struck down on the ground, in particular stated can be struck down that it is arbitrary under Article 14, went on to conclude that arbitrariness, when it is when applied to legislation, cannot be used loosely. Instead, it broadly based test stating that if a constitutional infirmity is found, Article 14 will be interdict such infirmity. Such a constitution is found in Article 14 itself, wherever legislation is manifestly arbitrary, that is, when it is not reasonable, discriminatory, not transparent, capricious, biased with favoritism or nepotism, and not in pursuit of promotion of healthy competition and equitable treatment. Positively speaking, it should conform to the norms which are rational, informed with reason, and guided by public interest. Then, my Lord, your Lordship will turn to paragraph 100. The part which I have already read. That we have already seen that one of the tests of challenging the constitutionality of subordinate legislation is that subordinate legislation should not be manifestly arbitrary. Also, it is said that subordinate legislation can be challenged on any of the grounds available for challenge against plenary legislation. Now, my Lord, this is what is before your Lordship impugned order or the resolution is a subordinate, is a piece of a subordinate legislation. The test of manifest arbitration is well explained in two judgments of the court and Kodai Distilleries and State of Karnataka. And then, my lord, they have quoted paragraph 13 from the Kodai Distilleries case. And trouble your lordship with that particular paragraph. It is next.
You may not, sir, you may not trouble us there because manifest arbitrariness has become a ground for striking down plenary legislations. So Kodai is overruled. Overruled decision need not be read. Now we have to show the decision is arbitrary. Earlier that was confined to delegated legislation, subordinate legislation, whatever name they may have, but never extended to the plenary legislations. Now they are included in plenary legislation. Now based on that premise, you can build the argument now. Overruled decisions.
Coming to how this act is arbitrary in the facts of the case, my lord.
Yes.
Now I will turn to the affidavit or the response that is filed by the government, my lord. And let us see, my lord, that how and in what circumstances this particular impugned action or the state action was taken, my lord. So your lordship may turn to the rules which are quoted, and Dr. Kumar has already pardon me?
Yes.
Your lordship will see that under these rules, that rule 11 provided that there should be a notice if you want to if you want to prescribe a uniform of 1 year prior notice.
That is for changing the uniform, not prescribing. Please read 11.
Every recognized may specify its own set of uniform. Such ones specified shall not be changed within a period
for changing, therefore that applies where you want to change the uniform. For prescribing, no notice.
1 year advance notice.
I'm applied to your law. When an education institution intends to change the uniform as specified in sub-rule 1, above it shall issue notice to parents in this regard at least 1 year in advance. Here in this particular case, what happens? That these girls are also wearing the headcraft since they've joined the institution.
Whether it was part of the uniform.
Not uniform prescribed does not also prescribe that nothing else should be done. Supposing a girl is wearing a glass, can you should wear the glass of a particular color only? And you bring the same color of the glass that you are not permitted. You cannot take it so strictly and rigidly that when you say that this is the uniform, and uniform must also include something else that is also worn by her. Supposing she is not wearing, she is wearing a shoe and they are wearing chappals. It's not prescribed. And tomorrow's day you will not wear chappals, you will wear, and therefore you are prohibited from entering the school. So, my lord,
whether any headdress was prescribed in the uniform?
No, it was not prescribed. So, but the footprints were not prescribed.
It was neither part of the uniform nor prescribed as uniform.
That was a mandate that you have to wear the uniform, and it's not the case of the girls that they were not made uniform, but they are merely putting one more apparel on their head. Supposing, my lord, a girl comes barefooted one day, can she not come? She is wearing the uniform, but next day she says you will wear chappals, or you will not wear chappals or footwear in the classroom. And some girls start wearing chappal. And on that girl said, you go get out and you don't come into my class and stand out. So, my lord, these are the so therefore, my lord, what happens when we say uniform, we can't so strictly confine to the dress which is worn. But what is the practice which was there? What was the practice adopted in the school, and all of a sudden you change it? Is it not, my lord, reasonable or fair that you should give at least a notice to the other side? And now you will not be allowed to wear, or why should you not change? And the reason why we are not changing, the fairness would require that they should be informed. And the fairness also requires that they should be heard as to why they're insisting on changing. And thereafter, my lord, the parents teachers committee is also formed with a view not to create any kind of a trouble in the school. And that is also, that procedure is also not followed. That is the case of university. And
to say that notice was required to be given first.
Notice
before
fairness requires that notice should be given. Rules may or may not require. But fairness requires, and that is one of the grounds on which I can raise the plea under Article 14. Is it a fair procedure? On the ground of fairness, it is required that they should have been heard. The parents should have been heard. The girls should have been heard. And if they did not want to give the notice, that they should have asked the parent teachers committee which was formed. And try to, Milord, your lordship will see, Milord, that Rule 12, Sub-Rule 5, Milord, which is the internal page 11 of the government's response, Milord. The functions of the parent-teacher committee shall be as follows: to redress the grievances of the students and their parents. Why the parents and teachers committee was not consulted? With respect, is a question that I'm putting to myself. Was it not fairness? What is that tearing hurry with it? The practice which is there in the school for nearly since the day when the girls are admitted or have taken admission into school, they want to change it. What is the need for this tearing hurry? The tearing hurry is this, that some boys are or some students are objecting, and are they objecting on the ground of the religion? Or this is it's an opposition to the girls' own. That opposition as to why they want to wear a different dress, on what ground, on what they are claiming that. They are not placing their claim on any religion or any of the rights. And to accommodate, because you are objecting, you don't come. Is this fairness? All the more reason why they should have called the parent teachers and to redress the grievances of students and their parents, if any. Call both the sides together, talk it over to them, and bring a solution. At home, the government did not even. So these are the grounds of manifest arbitrariness.
All right.
And this is being done only on the ground of this. And that point has been very elaborately explained by my learned friend, spoke to your court before me, and so I will not repeat those grounds.
All right. Now, anything else?
Not your lordship will see. Then your lordship will see that the fact that it is being done because of the opposition of some other students is also recorded in the impugned order, in the government response itself, and also in the impugned order. So it is partisan. So it is totally unfair, and therefore it falls within the mischief of the manifest arbitrariness, which is a part of Article 14, my lord, and therefore it has to be set aside. Now, your lordship will say that my learned friends Sanjay Hegde and Mr. Kamath elaborately explain the Article 25.
Yes. That we have.
No, your lordship will see.
Now we come to.
No, your lordship will see. I want to one point that they have not stated, which I would like to slightly elaborately state before your lordship, and your lordship may give me some patience hearing on that. That under Article 25(1), when the right is based on Article 25(1) and also 19(1)(a), what is necessary is that entertainment of a conscientious belief by a particular individual. Your Lordship knows very well that Article 25 deals with the individual's freedom of conscience. Now, Your Lordship may kindly please turn to Article 25. And the distinction that I want to draw is this.
What do you want to?
I'll tell you.
Yes.
I want to tell Your Lordship that when the velayat is claimed under Article 25(1) as a matter of conscience, then it is not necessary to go into the question that whether that belief is held by that person is an integral part of his religion or not. The question whether a particular practice, religious practice, is within the integral part of the religion is relevant only under Article 26b. Then it talks of the denominational rights, and not when the person or the petitioner before Your Lordships are making the case under Article 25(1) about a religious belief. Now, Your Lordship will see Article 25(1). Your Lordship are very familiar with the words, but I'm just emphasizing one thing. Subject to the public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience. But then drawing distinction between the two, freedom of conscience and a right freely to practice and propagate religion. The conscience would mean is a very wider term. There are people who may not believe in God, yet they are entitled to that belief in conscience. There are people who believe in universality of religion. They may not accept any one particular religion, but they believe in all religions. They are entitled to that belief. And if they come before Your Lordship and say, okay, this is my belief, I should be protected. And then the question, what is the integral part of your religion? In my respectful submission, my Lord, that is not necessary. And my Lord, this very issue is now being referred to the 9 judges bench, my Lord, and in reference from the Sabrimala's case, my Lord. And therefore, my Lord, this question, how far the court can interfere with the religious belief of the people and entertain all the arguments relating to that whether they are in consonance with this article or that article.
Yes.
But therefore, my Lord, in our case, my Lord, no doubt, my learned friend, Mr. Kamath, has dealt with that question and said it is an integral part. Wearing a hijab is an integral part, and there he has, my Lord, laid the basis for that by referring to his own pleadings and the reference to the certain Quranic verses over there.
We have understood. You are saying that it is not necessary that it should be an essential religious practice for the purpose of attracting Article 25(1).
And the belief has to be protected. And
Yes.
then you are that this particular act is also forms part. The belief also comes part of the freedom of expression in 1918. And your Lordships are very, very much familiar with the Puttu Swami's case, my Lord. And my learned friend, Mr. Hegde, as well as Mr. Justice Kamath, referred to the view of Justice Chalameshwar, in which he said that a right to believe also a part of the freedom of expression contained in under Article 1A, 19(1)A. That passage is read before your Lordship. Now, having read that passage, my Lord, I will also like to draw only one more paragraph from Puttu Swami's judgment. Lord, the subject begins, concept and Manekan interplay between the rights. Your Lordship has got that judgment, my Lord, that 2017-10 SCC page 1. And therefore, my Lord, starts with paragraph 21, and I will not read those paragraphs. And there they trace the history of the development of the entire theory of the interplay of those articles. And your lordship may directly come to the paragraph 24 by page 350. I will not read the whole paragraph, but only the relevant extracts from that paragraph, my lord. If your lordship may kindly see 1, 2, 3, 4, 5, 6. And the 7th line on the top of the paragraph, my lord. The jurisprudence foundation, your lordship got it?
Paragraph number?
24, my lord. 359. The jurisprudential foundation, which held the field 66 years ago in MP Sharma and 50 years ago in Kharak Singh, has given way to what is now a settled position in constitutional law. Firstly, the fundamental rights emanate from the basic notions of liberty and dignity, and the enumeration of some facets of liberty as distinctly projected rights under Article 19 does not denude Article 21. So all the articles have to be read in conjunction with others, and one fundamental right reinforces the other. One doesn't denude the other. And it is expansive ambit. It is expansive ambit. Secondly, the validity of a law which infringes a fundamental right has to be tested not with reference to object of state action, but on the basis of its effects on the guarantee of freedom. And the lordship will say that here the impact is important, not the object with which they are doing. What is important is that they want uniformity, they want discipline. But doing this, are you impacting the rights of the others and the rights of the petitioner or not? And here the impact is on my right of 25(1), freedom of expression, my right of expression 91A, my right to take education under Article 21. All this has to be sacrificed in the name of the so-called name of maintaining discipline in the court. Are there no other ways in which discipline in the court can be maintained? Why are the Muslim girls who conscientiously believe that we must wear the hijab should be put to a Hobson's choice now? It's a Hobson's choice that either you educate yourself or you look after your conscience. Why? Is this fairness? Is this a state action? Guarantees the freedom which are guaranteed in the Constitution. And this kind of Hobson's choice which is placed on the girls, my lord, should be disregarded. And then your lordship will see that this action which is they have launched upon is also opposed to fundamental duties of a citizen, guaranteed under Article 51A. And my lord is also shown and incorporated a statutory form in section 7.2 of the Karnataka Education Act. Your lordship says section 2, Karnataka Education Act. Your lordship are very familiar, but they are actually reproduced in the act itself. The lordship may turn to subsection 7 of the Karnataka Act, and we say that under subsection 1 may also include schemes in respect of and come to clause G. Clause G. 7 subsection 2 clause G. Inculcation of the sense of the following duties of citizens enshrined in the Constitution, namely, and then my lord, they are enlisting all the duties. And my lord, your lordship may see the Roman 5 to promote harmony and spirit of common brotherhood amongst all the people of India transcending religious, linguistic, regional, and sectional diversities to renounce practices derogatory to the dignity of women. So, my lord, this particular practice, are we supposing to promote harmony or dissension on the basis that your wearing particular hijab is disturbing us? Is it not a violation of the constitutional duty, the fundamental duty which is expressed in Article 51A? And incorporated, why is it incorporated by the legislature, my lord, in subsection 2? And your lordship has just section 133. In what circumstances section 133 can be invoked, my lord? It is for the purposes of the act. The act is to promote harmony. The purpose of the act is not to create a dissension among the students. And when the established practice is there, then why should we have this kind of an attitude? Why should the school or why should the government come out with this type of an activity or this type of impugned sub-legislation? Then harmony, the spirit of common brotherhood, are we promoting that? Among all the people of India, transcending religious, linguistic, regional, social diversity, renounce politics, derogatory dignity of women. That is
Yes.
Then my lord, very next, value and preserve the rich heritage of a composite culture. The Constitution itself, my lord, takes into account the diversity that exists in our country.
All right, Mr. Yusuf, we have understood what you are saying. Will you be able to finish today? Because now we are at the end of the day.
If your lordship may give me some time tomorrow, I'll be happy.
Any other point to elaborate?
Yes, my lord. The other point is very important point, my lord, that this is also, my lord, mainly referred to by Mr. Thomas in his, but he has not elaborated the proposition, the doctrine of proportionality. The doctrine of proportionality, my lord, totally ignored. I will like to dilate a little, my lord. I will not take much time. I will not repeat whatever my learned friends have said. I'm merely trying to elaborate some points that they have merely referred to. And I'm making a very important point.
That you elaborate in your written submission. Give the written submission. We will consider.
Your lordship, give me 10 minutes more. I will just refer to it, my lord. I'll just refer to it. Your lordship,
yes, we have noted.
Doctrine of
we have noted the proportionality. You want to elaborate on that? We have already noted it. So if you want to elaborate it, give it in written submission. We will see that.
Either you give me 10 minutes today or you give me 10 minutes tomorrow. I will not go in detail on it. Because what is the doctrine of proportionality, my lord?
What more you want?
Components, that I just want to read, my lord, and I want to show to your lordship a judgment of the Supreme Court, my lord, in which they have shown what is meant by doctrine of proportionality and how that has been totally ignored here, my lord. If your lordship gives me 10 minutes more today or 10 minutes tomorrow, I'll finish it. And I promise your lordship, I will not, and as your lordship has been kind enough to give us the permission to put a written.
Finish your arguments today. Today, so that we may hear the other.
Your lordship. Much obliged. My lord, I will request your lordship to judgment. My lord, it is in the case of Modern Dental College and Research Center and others versus State of Madhya Pradesh, reported in 2016, 7 Supreme Court cases, page 353.
Yes.
I'm sorry, my lord. I request my instructing advocate, my lord, to hand over the copies of those judgments to your lordships, my lord.
Yes. Paragraph?
Yeah, Lord. Paragraph 59, my lord. It is at page paragraph 59. Page 373. But at page 412.
Yes.
Your Lordship is a page, paragraph 59, my Lord, I will skip it because to merely reproduce 96, your Lordships are very familiar with it. Then, my Lord, I read sections, paragraph 60, my Lord, which is of utmost importance. Another significant feature which can be noticed from the reading of the aforesaid clause is that the state is empowered to make any law relating to the professional and technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. Thus, while examining as to whether the impugned provisions of the statute and rules amount to reasonable restrictions and are brought about in the interest of general public, the exercise that is required to be undertaken is the balancing of fundamental rights to carry on occupation on one hand and the restrictions imposed on the other hand. This is what is known as the doctrine of proportionality. Jurisprudentially, proportionality can be defined as a set of rules determining the necessary and sufficient conditions for limitations of a constitutionally protected right by a law to constitutionally permissible. According to Aharon Barak, former Chief Justice of Supreme Court of Israel, there are 4 subcomponents of proportionality which needs to be satisfied. A limitation of a constitutional right will be constitutionally permissible. It is designated for a proper purpose. Now, my Lord, your first thing, your Lordship, was our submission that this particular impugned action is not advancing the purpose at all. Purpose of the act. The measure undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. The advancement, the harmony is the real purpose of the act. And the measure taken by them is go much against the provision of harmony and also the fundamental duties that are enumerated in the Article 51A. Then 3, measures undertaken are necessary in that there are no alternative measures that can similarly achieve the same purpose with a lesser degree of limitation. Now, why not, my Lord, this? It's assuming that they want to have a uniformity, want to have discipline, then why not consult? Why not consult the people who are the stakeholder and who are the person affected, whose rights are impacted? Sorry, that there needs to be a proper relationship. Proportionality is strict or sensu of balancing between the importance of achieving the proper purpose and the social importance of preventing the limitation of the constitutional right. What is the constitutional right, my Lord, which are infected and infringed? Article 25(1), right to my conscience, right to my expression, my Lord, right to have my education, my Lord. That's totally disproportionate. Totally disproportionate.
All right.
This is the ground on which, my Lord, we attack. This, in addition to all the grounds which are mentioned by my learned friends, the 3 my learned friends who preceded me in addressing your Lordship. And, my Lord, I humbly, my Lord, thank your Lordships, my Lord, for inexhaustible patience in hearing this matter.
All right, thank you.
Your Lordship will give me the liberty, my Lord, to file my written submissions, my Lord. My Lord, your Lordship may prescribe the time within which we have to take. And, my Lord, I want to make clear, my Lord, one thing, that these are all grounds which are advancing at a stage of interim stage. I think the hearing of the interim application is going on, and not the final hearing. There is some confusion in my mind, my Lord. Your Lordship may forgive me for putting it before your Lordship.
Yes, what?
Interim applications are not yet disposed of. So this is the hearing on interim applications. Otherwise, we would like to argue.
We do not know how you people have started arguing. We have started hearing. That is all.
What are we arguing? The lordship have already passed.
I don't know whether you are making final submission or making your submission on interim relief application, because that has not been clarified.
Final, my lord. 10 hours your lordships have been hearing. It has to come to an end. It cannot go on.
And what are the interim orders? How is the
It has to be
interim
final, my
application
lord.
disposed of?
Your lordships have been
We
so gracious in
will like
giving
to
such
know
a
how
time.
the interim
Has to be
orders are
final.
disposed of, interim applications disposed of. Your lordship has granted certain.
We have not disposed of any interim relief application. Let it be very clear.
My lord, sir, hearing
On
is
the
final.
first day, we had passed some
interlocutory.
Establish only prima facie. At interim stage, you have to establish only prima facie case.
All right. We have heard Professor Ravi Verma Kumar in writ petition number 2347 of 2022. Mr. Yusuf Hatem Mukhalle, learned senior advocate, has argued on writ petition 3038 of 2022 for the petitioners. Court of tomorrow. Now, court of tomorrow at 2:30. We'll continue. We are left with writ petition number 3148
Please.
of 2022. That is a PIL.
Start with Milord.
3424 of 22. That is also a PIL.
Please.
This 3424-22, there are some office objections which have not been removed. So only 2 writ petitions have been left to be heard on behalf of the petitioners.
Tomorrow I may permit it to start with Milord. So I'll conclude within 10 minutes, Milord.
My lord, my petition 3418 is also complete. I have been waiting for
3148 is my petition.
3418. That's also complete. Is also required to be heard whenever your lordships will get time.
My lords, I'm party in person, Dr. Vinod Kulkarni.
Make one
PIL
submission.
is 3312.
One submission.
In 3 minutes, I'll finish off my submission, my lords.
In WP 2146, IA number 5 has been filed. Court may kindly recollect yesterday for some technical reasons it was not considered. A proper application has now been made, IA number 5, seeking a clarification, saying that its students will abide by the whatever uniform insisting upon, just to use the same dupatta to cover the head. Only no additional dress, sir. Seeking a clarification. Let the students get back to the class.
My lord, I am a petitioner in person. My lord,
Just a minute. Just a minute.
IA number 5 may kindly be perused. Kindly look at the
IA
page.
number 5 of 2022 in WP number 2146. Learned Advocate General, appearing for respondents, informed that he has received the copy of this application. He intends to file the objections to this application. He prays for is allowed. 2 days time to file the objections.
My
My lord, before Raju, I make one humble submission, my lord.
in person.
I connected to your lordship from Delhi, my lord. I have one submission. My petition was, your lordship was pleased yesterday to club my petition 3418. That was an order passed by your lordship. Whenever your lordship will get time after hearing other matters, my matter may be also. That's a separate.
Which is your petition?
3418 or 2022. Huzaifa is title. Yes. 3418.
3148 hai.
Yes.
It is 3148.
Yes, my lord. Huzaifa. Title is Huzaifa. Yes.
Yes,
Huzaifa.
we will hear you.
Please.
My lord, I am petitioning in person. I filed intervention petition in writ petition 2347 of 2022 today itself. So either I may be granted time or my this is very small petition. In that we have given the reasons that it should be not allowed their petition. So those grounds are we have pointed out in our intervention petition. So that maybe we may be granted time or it can be read by the Lordship. Today it was filed, my lord.
Written submission. What
No,
do you have filed?
Intervention petition, my lord.
Intervention applications will not hear. Sorry.
But
We'll
that-
hear the
my lord can read. The time may be not granted with the very material points for the assistance of.
If required, only then we will permit, otherwise not.
Yes, yes.
Take it that we
are not permitting anyone
to intervene.
No, but that could be read, my lord, for the administration of justice. That lordship, that's a very small petition.
Now there's one IA filed by Mr. K. Kotwal, advocate. R. Kotwal.
Please, lords.
Yes,
You have moved an application for impleading as proposed.
I am not pressing that application. I am not pressing that IA number 1, my lords. Since I have already
because what we find, we have also filed an impleading. Why not cost should be
I am
imposed?
not pressing the IA number 1.
How
number 1 is
without
not pressed.
that IA 1 of 2022 in writ petition 2347 is dismissed as not pressed.
Please, oblige me, lord.
My lord, I stand corrected by 3586.
Does not want to press this application. Dismissed as not pressed.
My lord, 3586 is my question. Sorry, my lord. I stand corrected. 3586. 3586.
Yes.
Yes,
We'll hear you.
please.
We'll hear you when you're
Please,
done.
grateful. I am highly obliged.
Lordship, may I make one submission, Lordship? In first two petitions, state has filed objections, Lordship. Permission may be granted to me to file rejoinders, Lordship. Because some facts they have stated, I will file written rejoinder.
Whatever you file it. Nobody will stop.
My lord, I am Dr. Kulkarni, party in person in WP 3312. If you can kindly